Welcome to the Jersey Justice Podcast, featuring your hosts, attorneys Gerald Clark and Mark Morris.
So, Justice Albin, there's an old saying, if you can't beat them, join them, or maybe if you can't beat them, have them join you. So tell us how you went from the prosecutor's office to Wilentz, Goldman, and Spitzer. Like, how did that all happen?
Okay. I was an assistant Middlesex County prosecutor, and in April of 1980, I was assigned to an arson trial. And the defense attorney in that case was Warren Wilentz, who was a renowned trial attorney and a preeminent figure in Middlesex County politics. Partner at Wilentz, Goldman, and Spitzer. His father was David Wilentz. His brother was Robert Wilentz, the Chief Justice of the New Jersey Supreme Court. So I tried that case against him over a period of about 2.5 weeks. And outside of court and during the breaks, we were civil. He regaled me with stories. But once the curtain went up, it was like a battle. But it was a very civil one. I'll give you one anecdote. So on a Monday, we would be in the hallway of the courthouse, and he would be regaling me about what he did over the weekend. He had gone to this restaurant, met with these people, and it was clear to me that he was having a spectacular time, as well he should, during the weekend. But I was saying to myself, I'm living a very boring life, because all I was doing was working on this case over the weekend and preparing for the case, which served me very well, because when the time came for Warren to put on his witnesses, I was able to basically carve them up like one after another. I wound up winning the case. His client was convicted. And about a 1.5 years later, when there was an opening, he called me to see if I was interested in joining the law firm. At that point, I had been in public service for about 5.5 years. At least from an experience viewpoint, I thought I was probably getting maybe diminishing returns. I had tried approximately 40 jury trial cases, and I was wondering whether or not I would be any good in private practice, and I wanted to also try my hand at some civil cases as well. So it was a great opportunity. I accepted it, and over the years, we became close friends. He was my mentor. He became a surrogate father. Was one of the best men in my wedding, and it's just a good lesson that your adversary isn't your enemy. And through a trial, you can find mutual respect with the person who is your adversary. And I have found that many very good friendships have arisen out of these contested cases. But no case is a better example of that than the one that I tried against Warren.
Great. Can you just give a little more advice or speak about that a little more? How do young lawyers and even more experienced lawyers, how do you balance, in these cases, you're fighting over people's lives, you're fighting over people's economic lives. Some people, if they lose the case, will become destitute, the criminal case. So how do you balance being at war on paper with someone and an adversary with not, and let's say a personal shot or an ethics thing, a false ethics allegation is thrown in the papers or shots taken at the adversary. How you're supposed to turn the other cheek? How, if you can give some more kind of guidance or advice as to how lawyers can best balance being the best advocates for their clients, doing the best job they can, but also having these relationships like you were able to form with Warren Wilentz.
Yeah.
How does that? That's a especially for young lawyers that are new at this, and they're nice kids are out of law school and they're being lawyers, and for the first time someone's taken a personal shot at them in papers and unwarranted. How are you supposed to still be a nice guy and shake their hand, and how does that work? How do you do that?
Well, I have found that taking the high ground is typically the better approach. It garners respect from members of the bench. And maybe in the long run with your adversary at all. Now, having said that, I don't want you to think that if I took a punch, that the other side wasn't getting two back. So I'm not saying that you have to be a pansy, but you have to remember that when these low blows are particularly being delivered on paper, like, you don't want to respond in the same way. Like an email, a letter, that's forever. That could be attached to an appendix. So I don't think I ever lost the case on the grounds of civility. So I think that is the best approach, that we should, try to lift up our profession instead of becoming the lowest common denominator and following your adversary into the gutter.
We find too. I read a lot of books on trial advocacy and stuff, and actually one of the books I'm working on is Trials and Triumphs from Chris Placitella edited this book, and there's a section in here from you that you wrote about appellate advocacy, which is interesting. But what these books talk about a lot is that one defense tactic at trial is to try to turn it into a spite match. So, and I've had this experience at trials in front of juries, where defense lawyers will try to bait our side into just turning it into a shouting match or a spite match, because then the jury is likely to throw their arms up and say, "We're not doing anything here," and then the defense wins and the plaintiff loses. So I think that's kind of consistent with what you're saying, that if you stoop down to that level in papers, if they take a shot at you and we respond or something, you're just both going down in the gutter. And when the plaintiff has a burden of proof in a case, the plaintiff's going to lose, and it's going to turn off the court. So I think that's consistent.
And I think that's particularly true before a jury. Like, when I've tried many jury trial cases, I never felt my contest was between me and the adversary. I have a witness before me. I felt that was the contest, particularly if I was going to cross-examine the witness. When it comes to presenting your own witnesses, you either prepared the witness properly or you didn't. And if you haven't done it, there's not much you can do to really assist in rehabilitating the witness during the course of the trial. And this is where really preparation comes into play. So I did not make my trials personal against the attorneys. I had a case to prove or a case to defend. And I recognized that the defense attorney or the prosecutor was playing a role. And my mission as a trial attorney was to persuade the jury. You're not persuading a jury if the jury has taken a view of you that is not flattering. And it's not flattering to get into spiteful exchanges with your adversary in their presence.
That's a good point. And so, Justice, working for the prosecutor's office so early on in your career, because I know, again, we always go through who are our listeners, and I imagine it's going to be some people who are in law school or thinking about going to law school. How did working for the prosecutor's office right out of law school help advance your career, get you trial experience, and prepare you, I guess, ultimately for a career as a Supreme Court justice?
Yeah. So the one great thing about going into public service straight out of law school is I was always the front person. I was never carrying anyone's bags. 1 week after I was sworn in, I was arguing before the appellate division. And in those early days, yes, I had someone review my brief. My name was on the brief, and I argued the case before the appellate division. And then when I went to the Passaic County Prosecutor's Office and the Middlesex County Prosecutor's Office, I was seated at that table alone. I don't think that happens today, but I had a trial partner who was basically known as the ghost, and I was there. I had a detective. I had no one supervising me from like day one. So, I was like learning at the expense of the state, but learning very quickly on my feet.
And something I heard too, I think I took a criminal procedure or criminal advocacy class at Rutgers Newark, and it was Judge Fulleylove, I believe. I think he recently passed away.
Yes, he did.
But he came and he spoke to our class, and he really recommended working for the prosecutor's office out of school because we talk about, Jerry and I do plaintiffs' personal injury cases. If someone's catastrophically injured and, we're anticipating we can get them a lot of money and we lose, that's a very difficult thing. That person, doesn't get money. If you're a criminal defense attorney, you think you have an innocent client and you lose your case, that person could be going away to jail for something they didn't do. And Judge Fulleylove was like, the prosecutor's office, if you're prosecuting a case and you lose and you don't see that person again, like hopefully they learned their lesson, that's it. And if you lose and they're a bad guy, you'll get another shot at them. They'll be back.
So I don't look at it that way.
There you go, your dissenting opinion.
I'll take issue with that. First, I'll say this, that the skills you learn as a prosecutor, the trial skills, are easily transferable into the civil arena.
Evidence, especially.
Because I did that. Now, I disagree with Judge Fulleylove because if you're prosecuting someone for like a really egregious rape case, like all rape cases are egregious, and when you think that the person is a serial rapist, you don't want to lose that case, okay? And say, well, I'll get him the next time after he's able to victimize 15 more victims.
Yeah.
Big time.
So I've had cases like that where like everything, as far as I was concerned, was like on the table. This is a case of incredible importance.
Big time.
Yeah. So I was looking for the next time around. I wanted to do justice now, and if I thought the person was a clear and present danger, get that person off the street.
Big time. And obviously, I'd say that I think that's an oversimplification, essentially, of the system. We spoke a little bit before we came on here. I started out with the prosecutor's office as well. I was in the appellate division, and then we would handle a lot of municipal court appeals. So I remember one of the last cases I had, it wasn't quite the one that you had where you went up and said, hey, I don't know if I'm going to take this. I didn't feel like necessarily I had the discretion at such an early stage of my career. And I remember one of the last files on my desk was these teenagers were doing a scavenger hunt. And one of the items on the scavenger hunt was to take a traffic cone. And so they took a traffic cone and got arrested for theft of government property. And they prosecuted it as a 2C offense. And it came on my desk, and there was an application to have it dismissed as de minimis. Basically, it's so small, it's such a little thing, it doesn't warrant prosecution. And I don't recall having any say in that. And Jerry called me and was like, hey, you want to come join? And I didn't leave because I didn't want to work that traffic cone case. But I'm curious what ended up happening with that.
Yeah. So along the lines of what I said from my first experience when I was interning and through later parts of my career, I was of the opinion that when it came to my professional responsibilities, my ethical duties, that is not a democratic choice. Okay. No boardroom can tell me what is wrong is right. That is a decision that like each individual has to make. And I would tell my interns and my actually law clerks that at some point in their career, like you may be pushed, not in some big way, but in some little way, to do some shortcut or do something that isn't like totally correct. And then you have to make your own decision, okay? Like whether or not you're going to go along with that or whether or not you're going to push back. That request is just exceeding your professional duties. And look, the examples I have given you are not the like only ones that
Sure.
occurred in my career. When I was a prosecutor, I remember preparing for like a drug case, and I met with a state trooper. And as I was preparing him for the stand, I saw that he had like a folder, and I said, "What's in that folder?" And he said, "Those were intelligence reports about the same case I was about to trial." try. And I said, well, those are discoverable. I've got to see those. He says, I never turn those over. Those are my files. Well, I said, well, you're going to have to turn them over because I'm not going to be trying this case unless I get that folder. And then that was in the evening. And the next morning, I went to the chief of the trials section. And I said, there are reports, okay, that I believe are discoverable. I am not trying this case unless those reports are turned over to me. And I said, and there are two good reasons for that. Number one, we have an obligation to do that. Number two, if he is put on the stand and asked the question, is this the only report that you have prepared? I am not going to be silent on that account. So that was another one of these instances where I've said, this is like my point. This is my breaking point.
Yeah, because the job of a prosecutor under the law, like we talked about earlier a little bit, is not to win cases. The job is to see to it that justice is done. I think that's the phrase from the law on that. But tell us if you can, Justice. So how does one become a Supreme Court justice in New Jersey or otherwise? If you could tell us a little bit about that process, how it happened. And I remember I was reading a book by a former president, and it was really cool because he was saying how he put him in a typical day of a president's life. You wake up, you walk past the Rose Garden, you go in, and he says, after a while, it's just another job, And I thought that was a fascinating story about putting oneself in the shoes of the President of the United States and what that's like each day. So if you could talk a little bit about that, I think people would love to. What's that like? Like, how did the process start? Did you apply for the job? Did you somehow put in an application, interview? Like, how does this work? And then once it happened and you got sworn in, like, what was it like? And another question I have too, and not a lot to unpack, is like, with these dissents that you write, like when you're a new justice in there, are the other 6 justices like, just sit down, this is how this works around here? Like how does all that work? And then when you're disagreeing and you dissent, is there sometimes some hard feelings? Do you not get invited to lunch the next day? Or like, how does all that work? The process of becoming it, and then each day, if you could put the folks in those shoes for a bit.
A bunch of questions there. I'll start with the question of how did I get there?
Yeah.
And then I'll talk about what did I do once I got there?
Yeah.
I left the Middlesex County Prosecutor's Office in 1982, and around that time, a very young person was joining, and almost figuratively, I'll say we bumped into each other. And once I joined the Willents firm, he would see me in the corridor and seek me out. We would talk, give him advice. His name was Jim McGreevy, the person who would later become the governor of the state, and the person who would appoint me to the Supreme Court. So we became like friends over those years. I counseled him, and I watched him develop.
Was he a client of the firm or an attorney?
No, he became an assistant Middlesex County prosecutor.
Okay.
So while he was an assistant Middlesex County prosecutor, and now I was a criminal defense attorney, he would see me in the corridor, and we would chat and talk, and a friendship developed.
Did you ever were you ever adversaries in cases?
No, I don't recall ever having a case against Jim. And when he left the prosecutor's office, we maintained contact and a relationship. And then he ran for the New Jersey Assembly, then for mayor of Woodbridge, ultimately for the New Jersey Senate. And I was there helping him along the way. And he ran for governor in 1997, and he lost in a very close race to Christie Whitman, and then he ran again in 2001. And I was helping him out during the course of those campaigns. But I don't recall, I shouldn't say I don't recall, I never said to him, I'd like for you to appoint me to the Supreme Court. I actually had a greater desire to be like the Attorney General. If anything, I thought he would appoint me to that position. Not that I was lobbying for the post. I wasn't. But in 2001, after he was elected, and while he was the governor-elect, we had a dinner. And it was then, for the first time, he said that he wanted to put me on, when there was an opening, he wanted to put me on the New Jersey Supreme Court.
Was it a dinner like, hey, we need to meet, or was it just, hey, what was your understanding the dinner was supposed to be? Was it just, we were just going to catch up on things, or, hey, I want to talk to you about something?
No, I knew it was going to be,
okay.
He was putting together his administration. If anything, I would have thought that he would be discussing the position of, like, Attorney General. So it was like a total surprise to me that he had, like, raised the issue. I did remember one time, maybe months earlier, when Jim, Governor McGreevey, and Warren Lentz, with whom he was very dear and close friends, and I were having a lunch. I remember him just saying, hey, wouldn't Barry make a great Supreme Court justice? But I really didn't pay much mind to that. And then he, raised that for the first time. I could have pressed him, perhaps, to become the Attorney General, but I figured I'll just leave matters in his hand and let's see what turns up. And in politics, you never know what's gonna happen. So that meeting, I recall, was in really late 2001. And the next opening on the Supreme Court wasn't supposed to be until 2003, because Justice Coleman and Justice Stein were both retiring in June. They were hitting the mandatory age of retirement. And it was in approximately April of 2002 that Justice Stein announced that he would be retiring from the Supreme Court at the end of August. And I recall getting a call from the counsel to the governor saying that Governor McGreevey intended to appoint you to that position. Okay, he wouldn't make the announcement for quite some time. And I remember responding, he can't do that. Because Stein is a Republican, I'm a Democrat, and there has to be the constitutional balance on the court. And he said, no, we've researched this. So the rule is that you can't have more than 4 members of any one party. And I would have been the 4th Democrat. At the time, I thought that the deciding one was the Chief Justice, what party the Chief Justice. So so that was a really surprising thing to me. And then in July, he announced that he would be appointing me to the Supreme Court, and that went by pretty smoothly. Okay, so now I'm on the court. You're asking me,
Let me ask
a
you,
day in the life.
Was it a pay cut?
Oh yeah, for me it was significant.
So would you talk a little bit about that? Because I think people would like to know about that a little bit in terms of, oh, it'd be great to be a judge, or I want to be a judge. And, how does the pays of, in New Jersey, at least, the pay, in terms of government service as a judge versus private practice, and how does that factor into it all in terms of getting a good judiciary?
And sorry, Justice, but just to set the table, and you'd been in private practice now for 20 years with the Wilentz firm. You're a partner at that firm?
I was a partner. I was on the management committee. I was on the partner compensation committee. And I had a very successful practice. I was doing quite well. But I had gone into the law for the purpose of trying to make a difference. You're able to make a difference in private practice. Personal injury attorneys do it. Everyone's making a difference in one way or another. I was doing criminal defense. I was doing civil rights work. I was very proud of that. I was handling some law against discrimination cases. But I always knew that if I was given the opportunity to serve in a position in public service where I felt I could make a difference, I would eat the pay cut. And it's a rare opportunity to receive an appointment to the New Jersey Supreme Court where you can really make a difference at the highest level. So that was pretty much a no-brainer for me. I was willing to sacrifice the income that I was making. Of course, that presents, your family is also going along with that. But I had the full support of my wife. and therefore I undertook one of, jobs that one could say is a dream job, and the opportunity to serve on the highest court of the state and to make important decisions that are affecting the development of the law and affecting tens of thousands of our fellow citizens.
Yeah, just so people know, when someone says make law, who makes laws? Well, the legislature makes laws, but also the Supreme Court also makes law. Can you talk about that a little bit, just so people understand it? Again, you've written 400 opinions, I think 230 or 40 majority opinions, and I know in that regard you've probably made more law than many elected officials and legislatures. Can you talk about that a little bit so people understand? And how does the fact that you're quote unquote making law and writing opinions inform or impact what you're writing and your approach to it all, knowing that you're making law?
Right.
And how are you making law so people understand it?
Okay. So there are three buckets here. There's the common law, the statutory law, and there's constitutional law. So the common law is an area of the law where the judiciary has precedence because it's an area where the legislature has not occupied, an area of the law that has developed over hundreds of years. And in that particular area, the court is basically a policy maker. Of course, it's not supposed to be doing it in a great dramatic fashion because you're looking at past laws and you're seeing how they adapt to the modern circumstances of society. So in that area, particularly like personal injury law, the court has like a huge sway in terms of how the law will be developed and crafted. Like the area of like the common law where the court was determining civil liability in drunk driving cases that were written by Robert Willans. Then there's the area of statutory law. So the legislature is the preeminent expositor of public policy in the state, and courts have to recognize that. But statutes are products of compromise, and being so, they're not necessarily clear, and they're subject to sometimes differing interpretations, and then members of the court have to figure out like what was the intent of the legislature. Now, in those cases where I was involved, I wasn't attempting to superimpose like my will on the legislature. I was trying to figure out like what did they intend. So that was my objective. I didn't feel I was an activist judge in trying to interpret what the legislative will. The legislative will is supposed to be expressed by the court once we have an understanding of what their true intentions were. And then in the area of constitutional law, you're dealing with like broad concepts like due process, equal protection of the law, reasonable searches and seizures. Like how are they meant to apply to the circumstances in our modern society, circumstances that could not have been imagined by the founders of the Republic, or the drafters of the first, 10 amendments to the United States Constitution, commonly known as the Bill of Rights. That's why we've got to try to figure out in 2021 how these general principles apply to modern realities.
So then, you said you were appointed by a Democrat. So, and again, for our wider audience and maybe some of our narrow audience, are Supreme Court justices just another politician, so to speak? Are they political actors? Now, I know in New Jersey has very strict laws and ethics rules that require judges to be separated from politics once they get on the bench. They can't donate to political campaigns. Judges can't attend political events, and it's very separate. But putting that aside, to the extent justices are making law, are they essentially politicians? Like, what's the difference between law and written opinions and politics? Like, how is what you do on the court or did on the court any different than a legislature in Trenton making an argument and making a vote? And the context I'm asking you about this is, so I believe, and I always learned that the courts get their power from really, not really public opinion, but the U.S. Supreme Court gets its power from its legitimacy. And I think that there was, I forget the opinion, it was an opinion probably in the 1800s or maybe early 1900s that the president disagreed with. I forget what it was. And after the Supreme Court came down with this opinion, I think it was the opinion that outlawed slavery, might have been. And the judge and the president at the time said, well, I don't care what they wrote in their opinion, let them enforce it. And how can the U.S. Supreme Court can't really enforce anything? I mean, they have a few guards there with pistols at the courthouse. And I always learned in law school and otherwise that the Supreme Court gets its power from its legitimacy, and that's why. And I think, as I'm interpreting how you addressed the Lewis decision and the gay marriage issue, was I'm not going to go too far here. I'm going to go enough, and I'm kind of feeling the winds of change, and I'm going to kind of go with that and help to nudge those winds along. So if you can talk about that a little bit in terms of those concepts about how the court gets its real power, its ultimate power, perhaps being derived from legitimacy. It's a little bit of a complex question,
Yeah.
But in the context of the Constitution and Roe v. Wade, I think Roe v. Wade was passed in that decision came down in 1970s, if I recall, and it said that in the United States Constitution there is a right to an abortion. Now, the text of the Constitution does not say anywhere there's a right to an abortion, and it doesn't even say, the text of the U.S. Constitution does not say anything that there's a right to privacy. I don't think the word privacy is in the Constitution. But as I understand it, the court that established Roe v. Wade and read into the Constitution the right to abortion did it by, I think they call it the penumbras of the Constitution, which is that the right to privacy is implied in explicit language in the Constitution, such as search and seizure, and that's where they kind of derive that right to privacy from. But what might confuse a lot of people, including me, and including many members of the public, is from the time they wrote the Roe v. Wade decision in the 70s until today, when we have the Dobbs decision saying, oh no, that was all wrong, this is what it's, the text of the Constitution did not change at all. So is that Dobbs decision just the equivalent of the senators and congressmen just changing it? How is law different? And what's that? And is that whole Dobbs decision just a way to justify, a legislature or a senator can just make their vote, do a floor speech, and this is why it is? How is that speech any different than a written decision that changes the law when the basis of that change, i.e. the U.S. Constitution text, did not change between the time of the two decisions? And one more thing I'll throw out there before you could maybe talk about this is...
I should be taking notes.
Yeah, exactly.
Yeah.
No.
Oh, okay.
But this stuff like I toss and turn at night, and it baffles me. Okay, so we have that whole discussion about abortion and the Roe v. Wade versus the Dobbs decision, and the court in Dobbs said there's no right to privacy or no right to an abortion in the Constitution. But as I understand the Second Amendment on guns, the Second Amendment says you have a right to bear arms so long as it is as part of a well-regulated militia. And there's even language before that clause. But somehow that very specific clause that limits the right to bear arms as part of a well-regulated militia has, in today's society, transformed into 14-year-olds can own an AR-15 assault-style military weapon and carve up a school. Could you help me out here on this? Because I'm kind of baffled on all that.
Okay. I want to start at the beginning
Yeah.
of your question. I think it was Andrew Jackson who said the U.S. Supreme Court has spoken. Now let it enforce its decision.
That sounds about right.
I think it was like in the 1830s. So I want to push back a little bit on like judges making making laws. Judges aren't legislators. I said earlier, the legislature is the preeminent expositor of public policy in the state, and the Congress for the country. But when it comes to like fundamental rights, the Supreme Court is the final expositor on the meaning of the Constitution, and also the meaning of the amendments that protect individual liberties and the right to free speech and right to freedom of religion, the right to be free from unreasonable searches and seizures, the right to a fair trial, the right to counsel. So that's not an area. Judges are not politicians in robes. So I know that there are books that say that, and there are people who say that. But our jurists are doing their best to construe the meaning of a constitution or the text of a statute. And when it comes to construing a constitution that was drafted in 1787, where the Bill of Rights was drafted in 1791, that's not an easy thing to do. So, you have a couple of different schools of thoughts. So you have like originalists who believe that you can actually understand the original meaning of the founders. And then there are people who take like a more modest approach and say it's difficult to determine like what they really meant, because there may not have even been a consensus among them in terms of the meaning of those terms, like due process, maybe even the right to bear arms and its intersection with a well-regulated militia. So these are difficult things, and so society has changed dramatically in hundreds of years. Our consciousness of fundamental rights. Our free speech jurisprudence was not expounded at any length until the 1920s, from like 1791. If you look at the first major First Amendment cases, they're not until the 1920s, and that's when Olive Wendell Holmes is speaking to those issues. So now you're bringing me up to the Roe decision and the Dobbs decision and the right to privacy. The term is not found. That term, at least, isn't found in the Constitution, but it is like inferred from many other provisions, as you were suggesting. I don't think there's any like group at this point on the conservative end or even on the liberal end that's saying that there isn't a right to privacy, except maybe Clarence Thomas, who from the Dobbs decision is like suggesting that maybe all those other precedents in the late 1960s and early 70s should come into question. So, with respect to the right of a woman to choose, even Ruth Bader Ginsburg would later say that those decisions should have probably been developed in a slower fashion. We can go back to Lewis versus Harris to try to do it in a way that would try to build up some sort of consensus, although I think that's really unlikely to have happened anyway at any period, because the country is really deeply split on on that issue. So the original Roe decision had the benefit of stare decisis. Once a case is decided, it is entitled to respect and deference. And the United States Supreme Court justices who came before the Senate Judiciary Committee would typically be asked about that. And some of them, I think, might have even said that case is entitled to super deference because if they indicated that they had some sort of litmus test, they probably wouldn't have been able to get past the Senate Judiciary Committee. So these are part of the games that are played during the nomination process. Look, I think it was Justice Brennan who said, and maybe he said this in a cavalier way, in deciding a case, you got to count to 5 when you're on the United States Supreme Court. That's what it takes. From the 1970s to the Dobbs decision, the face of the Supreme Court dramatically changed. Maybe the country changed, but somewhat, got a little bit more conservative. But there's no question that between then, and the present, the decisive factor was a change in who the president of the United States was and who was being placed on the court, and that ultimately made all the difference. Now, Justice Alito, in writing Dobbs, said that Roe was egregiously wrong today and when it was first written, but it's only egregiously wrong because at that point he was able to capture a majority of people on the Supreme Court to reverse it. Now, having said that could cause a lot of cynicism and skepticism because we don't want to necessarily think that the Constitution is a document that is going to change depending upon who happens to be on the court at any particular time. But even the dissent, if you read the dissent in Dobbs, they're saying what's changed between 1970 and today? Who's on the court today? We can go to Plessy, Brown versus Board of Education, right?
So that's where it happened for the good, or it happened.
Well, depending on how you define the good, right? People define the good in different ways.
Well, the one that said separate but equal, and then the one that undid that and said no integration, nothing changed. But that was, most people I think would agree, was a good change.
Now they would, for sure. Okay.
Back then, there you
yeah,
go.
in 1954, it was a very contentious issue.
Yeah.
And certainly, it met with tremendous resistance in the South.
Who was that? Governor Wallace said what did he say? He said
Not the separate but equal.
no, he didn't even say separate but equal. He's
Segregation now, segregate forever.
Mm.
But he was not even governor then. he wouldn't become governor until the 1960s. So Brown versus Board of Education is an interesting case when you're studying against Plessy versus Ferguson. Okay, so Plessy versus Ferguson was decided in 1896 when their racial prejudice was at a high tide, and certainly, in the South, you had white supremacists who were attempting to, reestablish this Jim Crow regime. But there was one dissenter there. So you want to talk about the power of dissent. John Marshall Harlan, who said that the Constitution is colorblind. But he was not really speaking to an audience willing to accept that interpretation of the Constitution. The country wasn't ready yet. It would take another 50 years for racial attitudes to change. And with those changing racial attitudes and an understanding of the harm that racism was doing to the country, that changed attitudes also led to changing attitudes on the part of people on the United States Supreme Court. It didn't happen all at once. Yeah. In, I think it was 1947, Harry Truman ordered the integration of the United States Armed Forces. Jackie Robinson broke the color barrier. There were Supreme Court cases that were argued by Thurgood Marshall, integrating the University of Texas Law School, University of Oklahoma graduate schools, all leading up to Brown versus Board of Education. So, yes, in the case of Brown, there were 9 different people on the Supreme Court then in 1896. But it wasn't just that there were 9 different people. The country had changed, the attitudes of the people. And I'm going on a discourse on this,
it's important and
the
interesting.
other thing that people may not understand is that the sort of racism that was occurring in the South was a rebuke to the United States in its battle with communism. Okay, like the Soviet Union would turn to our racial discriminatory policies to really condemn us, and that was actually a concern of political figures. I think it was also a concern of certain members of the Supreme Court. Brown versus Board of Education.
That one I didn't understand. So Russia said we're a bad country because we segregate. We're racist, and then how did that affect the politicians here?
Well, we were in a Cold War with the Soviet Union.
Of course, yeah.
Attempting to win over like third world countries,
the hearts and minds of people.
Exactly.
Soft power.
So we're promoting the tenets of democracy when we are like suppressing a minority in our country. After World War II, when we were fighting a Nazi regime over its own racial policies,
Right.
and here we are, still carrying.
So that was a big spark with the changing the laws and the Civil Rights Act.
It's there. It's in the background.
Wow. I
I'm saying,
never knew that.
Yeah,
No, me neither.
it's in the background. Like people like Felix Frankfurter, who was on the Supreme Court, would have been like very much attuned to that. Not only the fact that the time had come to condemn the policy of state-sanctioned segregation in the South, but it was really like a rebuke to our democratic ethos and democratic ideals.
So
as
now
well.
now I'm getting a new perspective and appreciation for why the Supreme Court justices appear at the State of Union address in Congress, because they need to be attuned to everything, even though they're supposed to be separate or are separate.
Yeah. Well, I think that's probably a matter of tradition.
Yeah, but it's a good tradition.
I'm not saying it's a bad one, but if you think of Fiddler on the Roof, I don't know if you've ever seen it, and Tevye says, "Why do we do this? Why do we do that?"
Yeah.
And he says, "Tradition." And he says, "Why? I don't know. Tradition." So couldn't come up. We just do it because we've been doing it forever.
It's funny. You got another one, Jay? No.
Yeah, do you mind?
No, not at
Because
all.
it's kind of along the same lines. So when you separate the segregation cases, Plessy versus Ferguson, which permitted racial segregation, I believe, and Brown versus Board of Education, which required integration of the schools. By the way, didn't Brown, do you know, originate from New Jersey? Wasn't that a New Jersey issue?
No.
Or there was a Brown 2 or something from I thought. Anyway.
Yeah. No, Brown was actually a conglomeration of 5 cases.
Got it.
South Carolina was one of them, and Delaware was one. Trying to think, was Oklahoma in it? And interestingly enough, I'll just say this: we're celebrating the 70th anniversary of Brown versus Board of Education, which was decided on May 17th in 1954, and I was on a panel at the State Bar Center with a person named Nathaniel Briggs, and his parents were the plaintiffs in South Carolina, represented by Thurgood Marshall. Now, the reason I was here is because one of the roles I'm playing in my present life is I'm the mediator in a very large public school desegregation case, which I cannot discuss because I've already told all of the parties that the details of the mediation themselves are confidential. But I'm now sort of like involved in a case that is sort of like an extension of Brown versus Board of Education.
So when you separate those cases from the difference with the change in Dobbs, in terms, it appears the only real thing that changed in Dobbs is the makeup of the court, as opposed to the segregation cases. Also, society's changed.
I'm saying what other members of the court, without putting my own gloss on it.
Got it. Yeah, that is what one of the dissents pointed out, that the only thing that changed is the court. Hey, let's take a little break.